Thank you very much for joining me today and for your interest in the Supreme Court of Canada.
Forward to this opportunity to speak with you and answer your questions. It is always my goal to help you provide your readers, listeners, and viewers with helpful information and context that may improve their access to justice or understanding of our justice system. It has now been more than a year since the onset of this devastating public health crisis. A full year since we jumped into unplanned pilot projects that required new technologies, skills, and priorities. Indeed, the pandemic has proven to be a powerful agent of change. It has forced courts into the 21st century, just 21 years behind schedule. These new approaches tested long-held assumptions that once proved to be obstacles to modernization and reform, such as how adopting new technologies would be too expensive, too insecure, or would insult the dignity and traditions of the courts. Embedded in this thinking was always the assumption that change would be a choice, until it wasn't. À bien des égards, l'année
In many ways, the last year has been a blur. Something I'm sure you can all relate to. But I am pleased to tell you that the court is running seamlessly, with most employees continuing to work from home. We also have no backlog. The court's third annual year in review document, I think you have an example of it close by, the 2020 version, provides an excellent summary of all of the modifications made to the court and how we conducted safe in-person, hybrid, and virtual hearings. The Supreme Court has decided that virtual hearings will continue if parties want it that way. Overall, it has been a positive experience. I imagine that going forward, some clients would appreciate having the option to reduce the additional costs related to travel, especially for criminal matters where those costs are borne by the public. I also expect lawyers may appreciate less travel time to and from the court. I understand Zoom hearings are permitting some counsel to work more efficiently and serve more clients at once because they have spent less time en route to and from courthouses.
Canada cannot have a completely virtual justice system. Poverty is a real issue in Canada. So is the absence of reliable internet and phone service in some places, especially in northern communities. I have heard that virtual hearings have led to a lack of formality and respect in the courtroom. Nova Scotia Supreme Court Justice Mona Lynch even told the House of Commons committee an anecdote from one of her colleagues. She said that during one virtual family court case, when one of the parties asked the court to hold on a minute, they could hear the person order a double-double at Tim Hortons. Every matter that comes to a court is important, at least to one of the parties. While judges should have the ultimate discretion, most civilian witness testimony should be heard in person, where the solemnity and procedure of the courtroom truly highlights the seriousness of the matter being heard. These are among the many issues and barriers that surfaced during the work of the Action Committee on Court Operations in response to COVID-19. This group I co-chair with Justice Minister Lametti, along with attorneys general and public health officials, has produced national guidance on how to deliver justice during a pandemic. Le comité a travaillé.
The committee has proven to be focused and effective. Its work has led to legislative proposals that would make the criminal justice system more efficient. They include permitting accused persons to appear by video at preliminary hearings and trials, audio appearances for pleas and sentence hearings when video is not available, the enhanced use of technology to draw names of jury candidates, and revising the telewarrant process to help peace officers remotely apply for a wider range of investigative orders.
At our last meeting, we agreed to continue this work. Everyone on this committee is passionate about access to justice. We share many of the same goals and are working well together. This is good for Canada's justice system. Courts across the country are also embracing change. Many jurisdictions now permit parties to submit unsworn affidavits by email. This may sound trivial, but steps like these are clear signals that the justice system now has an appetite for modernization. Another element I would like to share is how, across Canada, our courts are more diverse than ever. According to the Commissioner for Federal Affairs, 45% of all federally appointed judges are now women. There is also increased representation of judges who are Indigenous, racialized, or identify as having a disability, or are LGBTQ2. When judges reflect the makeup of society, this builds public confidence in the justice system. Judges also benefit when they share a wider variety of perspectives and lived experiences. I would also like to make you aware that I welcome the government's bill to reform the judicial discipline process. The Canadian Judicial Council is currently reviewing the proposed legislation. But my overall first impression is that these reforms would bring more transparency and efficiency to how judges are disciplined. De plus,
and after 23 years, the Canadian Judicial Council has also updated its ethical principles for judges. The new version, released last week, reflects the scope of judges' work today, such as the exponential growth in self-represented litigants, social media, and makes clear the expectation that judges possess a high degree of cultural competence. Before we get to your questions, I imagine some of you may have questions about my responsibilities as Administrator of the Government of Canada. This is a good opportunity to inform you and Canadians about my legal duty to take on this role and what I have done over the last 5 months. The federal government did not ask for my help by chance. It's spelled out in the law. When a Governor General is incapacitated or resigns, the letters patent of the office state that the Chief Justice of the Supreme Court assumes the role of Administrator of Canada.
Third, I have given royal assent to 12 bills and signed 557 orders in council. I officially welcomed ambassadors and high commissioners to Canada, and I signed letters of accreditation for Canada's heads of mission. I was also honored and humbled to preside over virtual ceremonies for Canadian honors such as the Order of Canada, Meritorious Service Decorations, and Sovereign's Medals for Volunteers. I am proud to fulfill this constitutional duty. And yes, it has been a lot of work. I would like to specifically express my gratitude to the court's small but mighty protocol team and the staff at Rideau Hall for their hard work, expertise, experience, and support. Prochainement, en septembre 2000.
Looking forward to September 2022, the Supreme Court will hear 2 more cases outside of Ottawa, this time in the beautiful city of Quebec, just as we did in 2019 when we traveled to Winnipeg. The members of the court will also engage with people in the community.
These are valuable to helping the public understand the work of the Supreme Court, as well as its role in Canada's healthy and strong democracy. Maintenant, je suis disposé à...
Thank you, and I am now prepared to hear your questions.
Questions? Nous sommes prêts à répondre aux questions.
Thank you. Merci. We will now take questions from the telephone lines. Nous allons maintenant passer à la période de questions. If you have a question, please press star 1 on your telephone keypad. Si vous désirez poser une question, veuillez s'il vous plaît appuyer sur les touches étoile 1 de votre appareil. You may cancel your question at any time by pressing star 2. Vous pouvez à tout moment annuler votre question en appuyant sur les touches étoile et 2. Please press star 1 at this time if you have a question. S'il vous plaît, appuyez sur étoile 1 maintenant pour poser une question. The first question, la première question is from Dylan Robertson, Winnipeg Free Press. Please go ahead. Your line is open. Votre ligne est ouverte.
Hello, Chief Justice. Thank you for keeping up these press conferences. We really appreciate this being a tradition. The government has pledged to create an arm's-length body to review possible wrongful convictions after advocacy by David Milgaard. The process seems to be moving slowly, and I'm wondering how common you think wrongful convictions has been in Canada, and if you have any advice for the committee that's crafting this independent body.
Well, I understand that the committee will provide a report. I think that, of course, wrongful conviction, one is too many. And if the committee and the elected officials can understand and can put up and provide measures that would avoid in the future as much as possible wrongful convictions, of course, I would support that. But I will wait and see what will be the result of their work.
Thank you. And Chief Justice, I just wanted to ask about Jordan timelines and the pandemic. If we're seeing things like 18 months of continuous adjournments, I'm wondering if you're personally concerned about the risk of cases being stayed or tossed over Jordan timelines, and how you think courts should balance pandemic realities with the right to access.
Well, that's a very good question, and we'll see how it will develop in front of the courts of the lower courts. But let me be clear, unacceptable delays pre-existed this pandemic. So we cannot blame the pandemic for everything. It is obvious that the pandemic was very difficult on every Canadian citizens, every organizations, and the courts. But I was very much impressed by the fact and the way the courts, the judges reacted, adapted to this new reality, which happened back in March of 2020. They discovered new technology. For some, it was old, but for others, it was new technology. They tried to find new ways to make sure that justice would be released, especially in urgent matters. It was quite a challenge in family matters, for instance, in criminal trials, jury trials. So I must say that I was very much impressed by the way our courts reacted quickly to make sure that justice would be rendered. Now, we'll see how the courts will react, whether there will be a motion eventually in some matters to stay proceedings. We'll see. But we know what the pandemic has done, and actions were taken. And if actions would not have been taken, of course, that would be a different scenario. But I'm confident that the courts throughout the country have tried as much as possible, given this unprecedented crisis, to adopt new measures to avoid additional delays. But there will be backlog. There will be backlog. That will be a challenge, especially in criminal matters. And we'll have to keep a close eye on that.
Thank you. Merci. La prochaine question. The next question is from Tom Korski, Blacklock reporter. Please go ahead. Your line is open. Votre ligne est ouverte.
Thank you, Chief Justice. You wrote that climate change represents a grave threat to humanity's future. What have you done personally in your personal life and professional life to lower your carbon footprint?
Well, that's a good question. I try my best, just like you do, I'm sure. But I think that it belongs to every citizen of this country to do his or her share to lower our carbon presence on Earth. You referred to the decision that we released a few months ago. That was based, of course, on evidence that had been put before the court, evidence and arguments. And our decision, of course, was based on that evidence. So as long as and I would hope that every citizen of this country would do his or her best to contribute, the better it will be.
Forgive me, Chief Justice, I don't want to be probative. I walk to work. We don't use air conditioning. I almost never drive a car. So that's what I do, would do.
Well, that's everybody is different. I mean, so we have to look at everything, every action that we can undertake according to our needs, and also according to our means. It's not everybody who, for instance, can use a bicycle or could use a car, and it's not everybody who is able to pay for some kind of heat or air conditioning or whatever. So everybody must act according to his capacity. And it varies so much from one individual to the other. There's no basic rule for everybody. I think you have to try your best. That's not a very legal.
Thank you.
That's not a very legal precedent, but that's, for me, it's common sense.
Next question, please. On the phone.
Thank you. Merci. La prochaine question, the next question is from Estelle Côté, Radio-Canada. Please go ahead, your line is open. Votre ligne est ouverte.
Bonjour.
Bonjour, monsieur. Good morning, Mr. Wagner. There is a position that will soon be vacant at the Supreme Court of Canada. We know that many people are asking for someone who would increase the diversity of the court. So what importance do you find in staffing this position with someone from a minority group or perhaps an indigenous person? How important do you think it is to have someone from such a group for the Supreme Court? Thank you for your question. I think that's very much in the news these days. And I've said this many times. The courts obviously are essential to support democracy and the rule of law, but they always also have to benefit from the support of the people and have their trust. And one way in which we can ensure that is to ensure that people recognize themselves in their institutions, not just the courts, but all public institutions. But obviously, yes, also in the courts. So it is essential that the courts have members that represent society. And as I said it earlier, amongst the courts in general, we're moving in the right direction. We are seeing more diversity and amongst the people sitting as judges at various levels in various courts. So at the Supreme Court, we have a limited number, only 9 justices, and so we have to look at the diversity through that prism. But it's desirable, and I have said many times that I hope that amongst the next appointments to the Supreme Court, the authorities will indeed appoint people who are diverse, people who are of color or indigenous. And I think it is critical to maintain the public's trust in institutions.
I just said is that it is essential in order to maintain trust and confidence of the public in our Canadian institutions, that our institutions reflect diversity. This principle applies to the Supreme Court of Canada. And I've said many times that I would hope that eventually and as soon as possible, that appointments be made that would reflect that diversity. So that would help and build and improve the trust and confidence of the public in the Supreme Court, in the institutions in general.
Next question, please. Tonda?
Alors,
I thought it was, yeah, teleconference, please.
donc, comme
So as a follow-up, Ms. Always on the subject of the profile of the next judge that will be appointed, how important is it that that person be bilingual? Well, look, there's 2 answers to that question. The first part of the answer flows really from the perspective of the public, in the sense that I feel that all Canadian citizens have the right to present their cases to the court in one of the 2 official languages of the country, French and English. That is a fundamental right. And therefore, as a result, the justices hearing these cases must be able to hear and understand both official languages and speak in both official languages to ensure that the rights of Canadians be respected. In the same vein, it's always important to maintain the public's trust in our institutions, and particularly in the Supreme Court of Canada, that the judges also represent the diversity or reflect the diversity of society. And I think there is a way to combine those 2 objectives. But obviously, it's up to the public authorities to make its choices. They're the ones who appoint the justices, and they legislate. And so I'm telling you what I think as the Chief Justice of the Supreme Court of Canada. I think that we need to make access to the courts the easiest possible. And one of the ways in which we can do this is to ensure that citizens be able and to express themselves and be understood in both official languages.
Hi, Chief Justice Tonda McCharles, Toronto Star. I'm wondering, you spoke about your role as administrator of the government. Basically, you're the acting GG. And under that, you've approved you've given royal assent to a lot of legislation. There's more coming up. Many of those bills or laws will be constitutionally challenged at some point. Will you recuse yourself from those appeals?
I don't know if there will be challenges to those laws. I don't know. It's not for me to decide these things. It's hard to predict. But when I accomplished that role as administrator of the government, of course, it is a constitutional duty. It was my duty. And when I wear this hat of administrator, I don't wear the hat of the judge. And for me, I see no problems in doing that. I simply accomplish and maintain the law pending the appointment of the new Governor General. So I don't see any problems in that.
Okay, just on your last point, you don't see any problems in that. So I understood you there to say you won't recuse yourself from any future appeals. If I'm wrong on that, correct me. My second question, though, my follow-up is, I'm wondering if, Canada has had some Indigenous lieutenant governors, but in terms of the Governor General, I'm wondering if that role is in any way different. Is there an incompatibility between indigeneity and the role of the GG as representing the Crown? Is that qualitatively different? Do you see the role differently? Just if you could speak to how we reconcile indigeneity, Indigenous peoples, and that position.
Well, I think that's just to answer your first question, because it was not fully answered, I think. I just want to confirm to you that I don't have any intention to recuse myself, but because I did not give any opinion, legal opinion, or any type of opinion on the legislations for which I provided royal assent. To come back to your question, I met with twice with lieutenant governors in Canada for the last few months in my capacity as administrator. It was my pleasure also to meet with them. And there were lieutenant governors coming from different areas, different backgrounds. It was very interesting to exchange with these people coming from different areas. So it will be up to, of course, as you know, the Prime Minister to decide whether the Governor General should be Indigenous or coming from a specific area of society, and not for me. I don't have to decide these things. It will be to the elected official to do it, and the Prime Minister.
Go ahead. I think it's ours. Sorry. Good morning, Chris Logue with Global News. What have the challenges been as it pertains to your dual role as Chief Justice and Administrator of the Government of Canada? Has the Supreme Court been able to function as normal with you assuming other responsibilities? And what if an election is called and a new GG hasn't been chosen?
Well, I don't know if an election will be called. I don't know when the new Governor General will be appointed, so that's not of my resort. You could ask the Prime Minister those questions. As far as I'm concerned, for the last couple of months, since the month of January when I was the swearing in as administrator, of course there was an increase in the work. As you know, we continued the hearing of our cases just like it was scheduled. It had no impact on the work of the court. It had impact on my load of work, my workload, but not on the work of the court. But it was also a kind of privilege for me to act as administrator, because I was able then to discover some aspect of the work that I was not aware of. For instance, I met with many distinguished Canadians in every provinces and territories who contributed to Canada in various fields like the science, medicine, arts, and when I was presiding ceremonies to give them awards like Order of Canada, for instance. I've done quite a few of those. I also, I was also very much impressed with the way governments is working. We have strong institutions. And of course, that facet of the work I did not know before. So I also met with very good and competent, experienced people at Rideau Hall and at Privy Council. because of my work as administrator. And so it was a privilege for me to do that. It still is, because I'm still there, and I may have to sign some documents even today and meet other people. But also I was privileged because I was surrounded by strong teams. Our staff at the Supreme Court of Canada was very helpful, very supportive. The staff at Rideau Hall, was very supportive, Privy Council as well. So because of that help, it helped me to do both things. Extended hours maybe, but still, I mean, I was able to do it with my team and also with my executive legal assistant, Maître Thériault, was very, as you wrote, very helpful in my job. So, so yes, there was an increase, but it had no impact on the nature of our work at the court. Oui, alors ce que je...
Well, what I was saying, that the fact that I assumed these functions as the Administrator of the Government of Canada on January 23rd had no negative impact on the work of the court. We continued to hear the number of cases that were planned. I sat as often as all of my colleagues, and as I did over the last 3 years. It was just as often I was writing as many decisions as ever, and I managed to do all of that, amongst other reasons, because of the support of the people, the very competent people that I got to know, people who are committed, whether they're at Rideau Hall, and there are people with tremendous expertise there, and they were of great assistance to me, but people on the private sector side as well who supported me. And the team at the Supreme Court and the protocol people, my main advisor, Mike Thériault, have supported me tremendously. So I have to say to you that there has been an increase in my workload, that's clear, but it had no negative effect on the work of the court. But at the same time, it allowed me, as I said earlier, is that I learned some new facets of the work of the Government of Canada. I met many Canadian citizens over the last few months who have contributed to Canada in various ways. When I was overseeing these ceremonies of handing out Orders of Canada, for example, people in science, medicine, in the arts, from all walks of life. And for me, it was a great privilege to meet those people. And it was always very emotional for me, particularly some of the people I met. People who were in frail health, for example, there with their families and friends. And I was giving them their Order of Canada on behalf of the country, and it was very moving. So I've benefited tremendously from this personally. I also learned a great deal about the machinery of government, signing of documents, of decrees, of orders and councils, royal assents. So all of these mechanisms that caused me to realize that we really have tremendously strong institutions in Canada. There are weights and balances, checks and balances, and it's a system that has a great deal of transparency. That aspect has allowed me to really have the opportunity to discover all of these things through this additional task that I have, but which I feel tremendously privileged to have been able to accomplish.
I'm with CTV National News. It's widely speculated that there's going to be a federal election in the fall. And given your dual role, I wonder whether you would feel comfortable making a decision on a request from the Prime Minister to dissolve Parliament, especially given that that's a political decision about the same government that your rulings, the bench makes, are subject to.
This is an hypothesis. So we'll see whether that question arises. For the moment, I'm doing my job as both Chief Justice and Administrator. I was told that, just like you were told also, that a Governor General will be appointed as soon as possible. That's my understanding. And so I will maybe ask you to ask the question to the Prime Minister or to the Cabinet, but I take it one day at a time, insofar as I'm concerned.
Okay. And my follow-up, in your opening remarks, you talked about how the number of judges from diverse backgrounds is increasing. You also say that there's this requirement to be fully bilingual that's important to ensure that the rights of everyday citizens are allowed. But I'm wondering, there are some groups that say this requirement to be bilingual on the Supreme Court of Canada will actually create barriers for judges from diverse backgrounds who might speak other languages than French. So I'm wondering what you think about that and what can be done to remove some of those barriers so that other judges from diverse backgrounds who don't necessarily speak French but may speak other languages can still be allowed to get on the Supreme Court.
Yeah, just as I mentioned before, I take the view of the citizens of this country. I think that every citizen in Canada has the right to argue and present his or her case to the Supreme Court of Canada in one of the two official languages. And that means that every judge should be able to understand, to exchange with that individual, to that citizen, in one of the two or both official languages. So that's the citizen's perspective. And that's very important because it's fundamental to our society. So that answers part of your question. The other part is, at the same time, I've been saying for years now, and other people have been saying for years, and we're going in the right direction to invite, to promote, to make sure that people who don't necessarily can speak in both languages, official languages, learn the language, take lessons, take every step possible to be able eventually to apply to the Supreme Court of Canada. And it could be done. It could be done, and it will be done.
I think we're going back to the telephones. Opérateur, nous sommes prêts pour des autres questions.
La prochaine question is from Leslie McKinnon, iPolitics. Please go ahead, your line is open. Votre ligne est ouverte. Leslie McKinnon?
Sorry, Chief Justice, I was on mute. Good morning.
Good morning.
I'd like to ask you. Good morning. I'd like to ask you about something that Justice Abella said in a Maclean's interview that appeared this week. She said that she thought the makeup of the court has changed from the way it's been in the last 40 years. That there are people in the court now who see more merit in reining in their approach to the Charter and giving more berth or more leeway to Parliament. Is that something that you agree with, or what do you think of that?
Well, everybody has the right of his or of her opinion. That's one way to look at it. I will not comment on my colleague's opinion on that. The fact that the court has changed in 40 years, I hope so. And I hope it will change also in the future. That's why I was saying a few minutes ago that the court should, represent what society is, and eventually the court will change. It's normal. If a court doesn't change, it doesn't play its role, and I think that it would be in the best interest of society that the court, for instance, that there would be more racialized people on the court as judges, that Indigenous people be appointed eventually on the court, that we keep the gender balance that we have. We have 9 judges, so it will be 4 or 5 one way or the other. But for me, it's important that we keep this gender balance. Of course, it's up to the government, to the elected officials, to appoint judges, and I will defer to them. But I'm thinking out loud right now about my wishes, and so the court is very dynamic, just like the society is.
Thank you. If I just change the subject, you had fewer hearings this year, about half the amount that you normally would have, and that's because of the backlog in the courts below. I'm wondering if you have a sense of how bad that backlog is and how long it will take to clear up as the pandemic restrictions cease and as people can appear non-virtually in courtrooms.
Yeah, well, you are right. There is a backlog at the trial level. There is no backlog at the Supreme Court of Canada, of course, because we depend on judgments released by the Court of Appeal, and the Court of Appeals across the country depends on judgment released from the trial courts. So the real challenge will be for the trial courts, no doubt about that. And as mentioned before, back in May of 2020, me and the Justice Minister, Mr. Lametti, decided to set up this special committee to make sure that we could provide some support answers to make sure that the court would continue to operate throughout Canada to restore the court operations. And it was very, very efficient, very useful, very helpful, because in that committee, and there's a subgroup also, working committee, we were able to count on information, advice of attorney generals, chief justices, public health officials, and to determine what are the needs, but not in theory, in practice. So it was very useful to exchange information coming out from different provinces, identify the needs, and this committee has decided recently that we will continue to work. Even if the pandemic, thankfully, will end eventually, we will continue our work in order to support the justice system. And through this committee, we were able to suggest, for instance, amendments to the criminal code to facilitate criminal trials in Canada. We identified also measures to help people in the northern region to have access to justice. Those questions will be on our agenda for the future as well, in order to find solutions and remedies. You can also consult on the Federal Commissioner website all of our works, all the tip sheets that we prepared, all the remedies that we suggested, and the works are published on, are posted on this website. So yes, the challenge is with the trial courts. We will try through this special committee to help them to make sure that the backlogs would disappear, to help them, to help the northern communities as well to have access to justice, because they don't necessarily have internet and all kinds of problems technologically wise. So those questions are dealt with at the level of the committee.
Prochaine question dans la salle.
Good morning, Chief Justice Olivia Stefanovich, CBC News. Thank you for taking our questions this morning. I do want to follow up on the questions my colleagues have posed to you about your role, fulfilling the role of Governor General as Chief Justice, particularly because your predecessor, Chief Justice Beverly McLaughlin, she writes in her book that when it came to the same-sex marriage bill, that she wishes that she would have preferred not to have signed it. That's what she says in her book. And I'm wondering if you've had any concerns at all during your time fulfilling this role as Governor General, and looking to the future, since you will have to sign more bills into royal assent, if you have any concerns at all about this dual role, do you feel uncomfortable in any way?
So I understand that my predecessor had some concerns. She would have preferred not to sign it, but she signed it. She signed it because she respected her duty. It was her duty to do it. And just like it is my duty to do it myself also, although in a perfect world, everybody will recognize that, the Governor General in office should be the one who should be acting as the head of state. And but the law provides that if there's a vacancy, If for any reasons the position is vacant, it is the duty of the Chief Justice to make sure that the order is maintained, that the Constitution is protected, and that the government will continue to work in an efficient manner. So it is my duty, just it was like